Good morning. Welcome to the 200th District Court. We're here for cause number FN24, Aparicio. Ms. Valdez, I have read through what you've submitted, and I may just have a few questions, but if you want to go ahead and just kind of run me through the background of the situation and where we are and why this relief is requested.
Yes, Your Honor. This suit is being brought by petitioner Carlos Alberto Sandres Alvarado, and he has been he has in an informal way essentially adopted his stepson's best friend. They have been friends since they were all living in Honduras. The child was came to the U.S. as an unaccompanied minor. He was living with some family members in Houston and did not know them very well, did not feel very comfortable there. And the child actually reached out to Carlos's wife and asked if he could come stay with them. And Carlos and his wife Carla discussed it. They reached out to his mother in Honduras and they agreed to go get him. I mean, he's been living with them for quite some time now, I think possibly almost a year. And Carlos has essentially taken him on as another son. And as of this August, he has registered it at the Goodwill Academy so that he can take English classes and get sort of I think it's a high school diploma equivalency. And he is requesting special findings so that he may apply to USCIS for special immigrant juvenile status on the basis of being an abused, abandoned, and neglected child.
Okay. And the school that he's attending, I just wasn't familiar with that one. Do you know anything about it? I guess.
Yeah, that's it's I actually had one of my former colleagues from Raices helped him apply for that school. And it's one of the better options for people over the age of 18. It's it's a little bit more flexible. And so it's where we send a lot of our uh, where recently arrived immigrants who may be not best suited for a traditional high school setting because they've not been in a school setting before, or because they're a little bit older than your average high schooler.
Okay. All right. And let's see. I think the order that you have prepared has child support starting in September, but of course, I think I need to pick a date in the future. So I don't think
Yes.
I can set that retroactively.
Yes, Your Honor. November 1st would be great. I'm sorry. It's probably because I think I originally filed in August. And so I think that's why.
I figure that might be the case. So you agree that the court needs to change that to some
To a
date in the
future date.
future. Okay.
Yes, Your Honor.
And you suggest November 1.
Yes,
I think,
please.
okay, we will do that. Okay. And thank you for filing the evidence, the exhibits in the court's file. I did review all of them. So I think that I think I have everything I need to consider this request, and I don't think I have any other questions for you. Let me look back down at my notes and make
Yes, Your Honor.
sure. I mean, I think when this came in, I did have the question about because he was over 18, but I did find the family code provision that
You can
allows,
order, yeah, that we're finding him dependent and that he is eligible for child support because of the school that he's enrolled in.
yes. So I found that. Okay.
Yeah.
That would have been one of my questions, but I tracked that
Okay.
down before. So, okay. Well, Ms. Valdez, I appreciate you coming to court this morning and answering those questions for me. If you wouldn't mind either sending the final order in a Word format, or if you want to go ahead and make the change to November 1 and resend it,
Yes, Your Honor.
we will get it signed and sent to the clerk's
Good
office.
afternoon,
Everyone,
Great,
welcome
thank
to
you
the
so much.
200th District Court. We are here for an emergency hearing in cause number Rose Hill Special Utility District versus the PUC. We don't have a court reporter, but if we could start with just introductions of everyone who's here, counsel.
Yes, Your Honor, I'll jump in. This is Drew Miller with the Kemp Smith Law Firm. With me today is my co-counsel, Daniela D'Souza, and we're here today representing the plaintiff, the Rose Hill Special Utility District. I'll let others make their introduction, and I have just a brief request that's
Okay,
procedural.
go ahead, counsel.
Good afternoon, Your Honor. My name is Erin Snowdy with the Office of the Attorney General, and I represent the Public Utility Commission of Texas, and I'm joined by my colleague today, Jordan Pratt.
And Your Honor, my name is David Tuckfield. I'm here with Andy Barrett. We represent the landowners in both these cases, Blue Star and Squeaky Lomas, in this case and the one that follows.
Okay, thank you. All right, Mr. Miller, we'll turn it back over to you then.
Yes, and so I guess what I would like to suggest or request is that Your Honor call both cases, the one that's being heard now and the one that's being heard at 2:30 or scheduled to be heard at 2:30, because my presentation, my argument is really identical for both. And I mean, there's some minor factual differences between the two cases, but the arguments are identical. And so maybe it's overly formal, but I'm wondering if you'd want to therefore call both cases to hear argument that will be pertinent to both cases.
Okay, well, let me see if there's any objection from the Attorney General.
No objection, Your Honor. Our presentation will be the same for both as well.
Okay, and Mr. Tuckfield, what about for your clients?
We agree, it'll be the same.
Okay, so we'll have one hearing on both matters, and I don't know that I need to formally call the other case because, as I mentioned, on these emergency hearings, we don't actually have or offer a court reporter. But the other case is just cause number 8292. So you got one number more when it hit the district clerk's office. So we'll go ahead and take them up together, and Mr. Miller, you can proceed.
Okay, thank you, Your Honor. And also, I just want to thank you for being available on such short notice to conduct this hearing. Your Honor, by way of introduction, Rose Hill Special Utility District is a political subdivision of the state of Texas that provides retail potable water service to approximately 1,600 customer connections and to a population of approximately 4,800 persons in Kaufman County, which is east of the Dallas Metroplex. Rose Hill is located in an area that is undergoing significant and rapid growth. Rose Hill holds Certificate of Convenience and Necessity, or CCN, number 10849, which is issued by the Public Utility Commission of Texas, which obligates Rose Hill to serve and allows it to serve as the exclusive provider of retail water service in the area covered by its CCN. Your Honor, last Friday, Rose Hill filed two petitions initiating administrative appeals in the Travis County District Courts, challenging two orders recently issued by the Commission. These orders grant the petitions for streamlined expedited release filed with the Commission by two adjoining landowners, Blue Star Land and Squeaky Lomas. I want to make sure that Your Honor has copies of the two petitions and applications for stay of agency proceeding, which is a combined document. And
I do.
Okay. And we also submitted two forms of order, one for each case.
Yes, we
Okay.
received everything.
And the booklet with the important statutes.
Yes.
Okay, great. Your Honor, I want to spend a moment to map out how I intend to organize my presentation. First, I mentioned this earlier, the cases before you and our request for injunctive relief present very similar, if not identical, legal issues. There are some minor factual differences between the two cases, and I will likely identify those differences at the appropriate time. I will start with some background regarding the type of agency proceeding at issue here, which is the streamlined expedited release process. This background, I think, is important because it's marked by an unusual two-step nature it's that this two-step process, I think, that is what compels Rose Hill to be here before you today to seek this injunctive relief. So the first part of my presentation assumes that Your Honor is not an expert with regard to this particular regulatory process. If you are familiar with this process, and it turns out that some of this is review for you, for example, if you've handled a case involving this process before, please bear with me, because I promise I will only cover those aspects of this process that I think are necessary to understand why we're here today. After doing that, after going through that background, I will identify and go through the general requirements for injunctive relief, which apply here, and show how each of those requirements have been met in this situation. And in doing so, I will discuss and get into the particular facts of these cases. Your Honor, the statutory basis for streamlined expedited release is set forth in Texas Water Code section 13.251. That's found at tab C of your booklet. This statutory provision allows the owner of a tract of land that is at least 25 acres and is located in a qualifying county that is not receiving water service. I'll emphasize that, not receiving water service, to file a petition for streamlined expedited release of the tract of land from the CCN of the water utility. The purpose and intent of this process, Your Honor, is to allow landowners under certain conditions to have their properties quickly and efficiently released from a CCN where the current CCN holder does not and is not able to provide service, in this case, water service. The Commission has adopted PUC Substantive Rule 24.245, and that is found at tab D of the booklet, which implements, among other things, actually, the streamlined expedited release statute. A landowner seeking this remedy, the streamlined expedited release, must include in its petition a statement of facts that demonstrates that the tract of land in question is not currently receiving service. Accordingly, the petitioning landowner has the burden of showing that its tract is not receiving water service. If the landowner cannot meet its burden to show that its tract is not receiving water service from the CCN holder, the petition must be denied. On the other hand, if the landowner can show that it meets all of the statutory requirements for streamlined expedited release, the landowner's petition is to be granted. Your Honor, in 2014, the Austin Court of Appeals issued its opinion in a case entitled Crystal Clear Water Supply Corporation versus Texas General Land Office. And I've got that case is provided in tab E of your booklet. In that case, the Austin Court affirmed a decision of the Commission granting the General Land Office's petition for streamlined expedited release. In doing so and interpreting the governing statute, the Austin Court set forth the standards under which streamlined expedited release petitions are to be reviewed and how, in particular, courts and the agency are to determine whether a tract of land is or is not receiving water service for the purposes of streamlined expedited release. Among other things, the Crystal Clear Court noted that the term service is defined in Chapter 13, Water Code, is defined very broadly and includes facilities and lines as well as acts performed and anything furnished or supplied to the tract in question. The Austin court was emphatic that receiving water service does not necessarily require the existing CCN holders to supply actual water to the tract in question. Instead, the crystal clear court stated that whether a tract is receiving water service is a fact-based inquiry requiring the commission to consider whether the retail public utility has facilities or lines committed to providing water to the tract or has performed acts or supplied anything in furtherance of its obligation to provide water service to the tract. Your Honor, the PUC's implementing rule establishes an unusual two-step procedure for these proceedings. Under this system, the commission first determines whether the landowner has met all the requirements for streamlined expedited release and whether the petition should be granted. If all requirements are met, the commission issues an order granting the landowner's petition. And that's where we are today with respect to both of these instances, Blue Star and Squeaky Lomas. As soon as that order is issued, a second proceeding to determine the amount of compensation to be awarded to the CCN holder as a result of the decertification and release of a portion of its CCN commences. Your Honor, we are here today to seek a temporary restraining order suspending an agency proceeding in the two cases before you. Although we are requesting that this court act pursuant to its equity jurisdiction, our request is also made pursuant to section 15.004 of the Utilities Code, which is a tab A of your booklet. That section is entitled Judicial Stay or Suspension and states that while an appeal of an order of a regulatory authority is pending, the district court may stay or suspend all or part of the operation of the order. It goes on to say that in granting or refusing a stay or suspension, the court shall act in accordance with the practice of a court exercising equity jurisdiction. Rose Hill is here today to ask the court to issue a TRO to suspend the portions of the two commission orders under appeal, specifically ordering paragraphs 7 in each of those orders, which state that the proceeding to determine the amount of compensation to be awarded to the CCN holder, this second phase, this valuation proceeding, commences on the date of this order. So this second stage is already underway. It began on August 15th, 2024, and that is what we are seeking to have stayed or suspended. As I will explain, such injunctive relief is necessary to prevent imminent and irreparable injury to Rose Hill and to preserve the status quo while this case goes forward and can be decided on its merits. Your Honor, the general prerequisites for injunctive relief apply here to our request for a TRO. In granting injunctive relief, a court must first find that the applicant has pled a valid cause of action against the defendant and has requested some form of permanent relief. Second, the applicant must show likelihood of success on the merits of its lawsuit. And third, the applicant must show that if the requested injunctive relief is not issued, that the applicant will suffer imminent and irreparable harm for which there is no adequate remedy at law. Rose Hill will demonstrate that all these elements are present and it is therefore entitled to injunctive relief in both of these cases. As to the first requirement of valid cause of action, Rose Hill's pleadings on their face show that Rose Hill has pled a valid cause of action with respect to both cases. Second, Rose Hill's pleadings also show the likelihood of Rose Hill's success on the merits of its lawsuits. I will take some time to explain and not simply rest on our pleadings on that point. And in doing so, I will delve into and describe some of the facts of these cases. I will say before I get into those facts that many of these facts are undisputed and in fact have been acknowledged as findings by the commission in their respective orders, which are under appeal in these cases, to the extent that some of these facts, and that's particular with respect to the issue of imminent and irreparable injury, are not undisputed and need to be established. Those facts are supported by the verification and the affidavits of Ms. Essery, which are included with the petition. So I will begin with the facts that are common to both cases, Your Honor. The Squeaky Lomas and the Blue Star tracts are both part of what's known as the Arboretum Estates development, which is a large-scale residential, commercial, and industrial real estate development that is occurring within Rose Hill CCN, or if you consider, I guess, those areas to be portions may have been seen as being removed by the orders which are under appeal. These proceedings, both of them before the commission, these streamlined expedited release petitions by Squeaky Lomas and Blue Star, are part of a concerted effort by the owners and developers of the Arboretum Estates development, along with a neighboring city, to have the commission remove the entire Arboretum Estates development from Rose Hills CCN for water. There are actually two more agency proceedings seeking release and decertification of the remainder of the Arboretum Estates development. And those matters will likely find their way to the Travis County District Courts within weeks or months. The key question in both of the cases is whether the tracts are receiving water service from the existing CCN holder, which is Rose Hill. As suggested earlier, the landowners must show in their proceedings before the commission that their tracts are not receiving water service in order for those tracts to be eligible for streamlined expedited release. Again, whether a tract of land is receiving water service for these purposes is determined by reference to the broad definition of the term service set forth in Chapter 13 of the Water Code and by applying the standards set forth by the Austin Court of Appeals in the 2014 crystal clear opinion. In addition to being within Rose Hill CCN for water service, the Arboretum Estates development, including the Squeaky Lomas and the Blue Star tracts, are within the jurisdictional boundaries of another water district known as the Las Lomas Municipal Utility District number 4B. And I mention this fact, and I believe it's important, because in 2006, Rose Hill and that other water districts, along with two developers, entered into an agreement under which Rose Hill is to provide water service to the area that now comprises the Arboretum Estates development, which again includes Squeaky Lomas and the Blue Star tracts. Since then, since 2006, since 2006, Rose Hill has taken numerous actions and has expended significant funds to fulfill its obligations and its commitments to provide those tracts with water service. In particular, and among other things, Rose Hill has installed an 8-inch water pipeline to serve those tracts. Rose Hill has taken ownership of a 2-acre tract for a storage tank and an associated easement for a transmission line from that tank to a new take point for Rose Hill's wholesale water supply. Rose Hill has designed and constructed a 500,000-gallon storage tank on that 2-acre tract. Rose Hill has secured additional easements for a water distribution pipeline from that tank to the existing Rose Hill water system. And Rose Hill has acquired the rights to an additional 61 million gallons per year of treated water from its wholesale water provider. All of these actions, Your Honor, were taken by Rose Hill so that it could fulfill its obligation and its commitment to provide the tracts that comprise the Arboretum Estates development, including the Squeaky Lomas and the Blue Star tracts, with water service. Moreover, Your Honor, Rose Hill's fully active, pressurized 8-inch water line runs through one of the two Squeaky Lomas tracks and runs parallel to Squeaky Lomas's other track just outside of the southern boundary. Rose Hill's 8-inch water line, the same line, runs parallel to the Blue Star track's southern boundary across the road at approximately 120 feet from the Blue Star tract. What this means, Your Honor, is that Rose Hill is ready and able to quickly provide a service connection on its water pipeline to both Squeaky Lomas and Blue Star. It would take approximately 2 weeks from a request from Squeaky Lomas for Rose Hill to begin supplying actual water to the Squeaky Lomas tracks, take approximately 30 days from a request from Blue Star for Rose Hill to begin supplying actual water to the Blue Star tract. What this means is that under the definition of the term service, the broad definition of the term service in Chapter 13, and under the standards set by the Austin Court of Appeals in the Crystal Clear opinion, Rose Hill is providing water service to the Squeaky Lomas and to the Blue Star tracks. Neither Squeaky Lomas nor Blue Star can meet its burden to show that their tracks are not receiving water service from Rose Hill. These issues were all briefed and submitted to the commission. Interestingly, commission staff agrees with Rose Hill. As required under the commission's procedures, commission staff submitted recommendations on both the streamlined release petitions of Squeaky Lomas and of Blue Star. In both cases, commission staff concluded that the tracks in question receive water service under the Crystal Clear standard and recommended that the petitions be denied. Soon after this recommendation was filed, the commission's administrative law judge issued proposed orders for the commission's consideration, which also found that the Squeaky Lomas and the Blue Star failed to demonstrate that their tracks are not receiving water service under the applicable statute as interpreted by the Austin Court of Appeals in the Crystal Clear case. But when these matters came before the commission at its open meeting, the commissioners voted to reject the recommendations of its own staff and to reject its own ALJ's proposed orders and to grant the Squeaky Lomas and Blue Star petitions on the basis that those tracks are not receiving water service.
Mr. Miller, let me interrupt you just for a moment. I saw all of this in your filing. What I didn't see was, do we have an explanation for why the commissioners did the opposite of what their staff and of what the ALJ recommended or would have done? I don't think I saw that.
I think you're picking up on an important point, because the order itself doesn't explain the reversal. And I think that's a problem. And I think that's an error. I don't think it's not the error I'm leading with today, because the error I'm leading with today, Your Honor, is that the commission violated the statute by finding that the tracks were not receiving water service. But I do agree, and this is embedded in and it's one of our claims, and we will brief this, in detail, is that the fact that the commission did not explain its reversal signifies arbitrary and capricious action. It's like emblematic. If they can't explain it, if they don't explain it, then it therefore probably lacks rationality. And it does lack rationality here. Now, there was an explanation of sorts. The explanation is not found in the order. It's found in a memo issued by the commission's chairman the day before, the afternoon before they were to consider the proposed orders issued by the PUC ALJs at the open meeting. And in those memos, the chairman stated some ostensible reason for the reversal. With respect to the Squeaky Lomas, the commissioner got the facts wrong. The commissioner said that the basis for his urging of a reversal was that there are no facilities on the Squeaky Lomas tracks. That's just simply not true, and it's not supported by the record. The uncontroverted evidence, Your Honor, is that there is an 8-inch pipeline belonging to Rose Hill that's fully pressurized, that has water in it, that actually runs through one of the 2 Squeaky Lomas tracks. Meanwhile, the commissioner's basis for reversal is that there are no facilities, there are no Rose Hill facilities on the Squeaky Lomas track. So that basis, I'm not sure if that's the full basis, because it's not adopted in the order, but it was in a memo presented by the commissioner by the chairman to the other commissioners the day before the open meeting. He repeated that or something that effect during the open meeting, and the question was called, and all the commissioners simply voted in favor of his motion to reverse the proposed order and reverse the recommendation and grant the petitions for streamlined expedited release. And so,
Okay.
sorry if I use that as a soapbox, Your Honor, but I think that's correct. I think the order is devoid of a real explanation of why this reversal has occurred.
Okay. All right. I need to go ahead and cut you off, Mr. Miller. I think I fully understand your client's.
Can I go to irreparable harm? I mean, that's all
Oh.
by way of trying to convince you that we have a likelihood of success on the merits here. And I'm more than happy to move past that. I'm almost done with that, but I'll move past that to irreparable harm. Because
I'll just say these hearings are usually 15 to 20 minutes in total. We're doing both at one time, so I'll give you a little bit more, but I have protective orders and TROs coming in every minute. So,
and I just didn't want to take likelihood of success on the merits for granted. I wanted to be able to, this is dense stuff. And so, and I know probably my presentation may have seemed a little dense, but I wanted to not just say, hey, we rest on our pleadings and for the sake of likelihood of success on the merits, but I'll move along. And I don't have much more. I think this piece is shorter, but I do want to discuss imminent and irreparable harm. So that's the final requirement for injunctive relief, is to show imminent and irreparable harm for which there's no adequate remedy at law. Rose Hill's claim of imminent and irreparable harm solely concerns the second phase of the streamlined expedited release process. It's that second phase that Rose Hill seeks to enjoin and suspend. Pursuant to the rule, the PUC rule, and the agency orders that are subject to the 2 lawsuits, the second proceeding with respect to both of these tracks, both of these proceedings, is to determine the amount of compensation to be awarded to Rose Hill as a result of the release of those tracks from Rose Hill CCN. And again, these proceedings are already underway. I call them the valuation proceedings, and they commenced on August 15th, which is the date of the issuance of the order granting streamlined expedited release. Significant deadlines, Your Honor, are looming in these proceedings, and these deadlines are bearing down on Rose Hill quickly. By October 24th, that's just 8 days from now, Rose Hill must have an expert appraiser develop and submit an appraisal calculating an amount of compensation due to Rose Hill as a result of the release of these tracks from its CCN. This appraisal is a complex document which must cover and analyze numerous factors that are set out in the PUC rule. Simultaneously, the landowners are going to be submitting their own appraisal. Just 30 days later, a third appraisal, this one appointed by the commission, must make a determination on the amount of compensation, looking at these 2 competing appraisals that have been submitted. And that determination made by this third appraiser, appointed by the commission, is binding on the commission. Rose Hill will be required to spend significant public funds in connection with these valuation proceedings, including the cost of its own appraiser plus half the costs of the commission appointed appraiser plus legal fees. We estimate the cost to Rose Hill to develop and file its appraisals in these matters will be in the range of several to many tens of thousands of dollars. Also, Your Honor, once the commission makes a final determination on the amount of compensation due to Rose Hill. And once the landowners pay those amounts, another water utility may provide water service to the Blue Star and the Squeaky Lomas tracts. So, Your Honor, if the valuation proceeding is not immediately stayed or suspended, Rose Hill will suffer immediate and irreparable injury for which there is no adequate remedy at law. Rose Hill will have spent significant funds on both its own appraisal and on the commission-appointed appraiser and legal fees. Rose Hill will be unable to recover those costs if and when the commission's final orders granting streamlined expedited release are reversed or remanded. It's also likely that another water utility, namely the city of Terrell, will be providing water service to the Squeaky Lomas and the Blue Star tracts once the commission makes a final determination on the amount of compensation due to Rose Hill, and those landowners pay those amounts to Rose Hill. Rose Hill believes that as the proper CCN holder, it is rightly entitled to those fees and water rates, yet Rose Hill will be unable to recoup or recover those fees even if and when the commission orders, even if the commission's orders granting streamlined expedited release are reversed by the courts. So that's money that will have been spent on water service to the city of Terrell, which is rightfully belonging to Rose Hill, which Rose Hill will never be able to recover. So in conclusion, Your Honor, Rose Hill has shown that it has met all the requirements for injunctive relief and respectfully requests that Your Honor issue a TRO suspending the commission's valuation proceedings, all deadlines in those proceedings, and preventing those proceedings from going forward. I'm happy to answer any questions.
Okay. I'll hold off for now. Ms. Snowdy?
Thank you, Your Honor. Plaintiff is asking this court for an extraordinary remedy. They're asking you to halt 2 ongoing agency proceedings and prevent the commission from following the statutory process set out by the legislature for assessing compensation following an order of streamlined expedited release. But the primary authority that plaintiff relies on for this court granting such extraordinary relief, Texas Utilities Code Section 15.004, simply does not apply to this order under the Texas Water Code. So Texas Utility Code is a section of the Public Utility, or 15004 is a section of the Public Utility Regulatory Act, which is found in the Utilities Code. And PURA applies to electric and telecom utilities. The Water Code, which is the section, as Mr. Miller laid out, the streamlined expedited release is under the Water Code. That deals with the commission's authority over water and sewer utilities. The Water Code has its own section for judicial review, section 13.381, which is the proper judicial review statute that applies here in this case. So they're relying on this provision of PURA that seemingly allows this court to stay an order of the Public Utility Commission while that order is on judicial review to the district court. But they are reading that out of the context of this entire statutory scheme, which is PURA. So I would point this court to specific provisions of PURA. Chapter 15 is judicial review that falls under subtitle A, provisions applicable to all utilities. Sounds like it might apply here, but utility is defined within PURA at 11.004 of the public utility of PURA. And that says in subtitle A, the subtitle that 15004 falls under, utility means an electric utility or a telecom utility. This is further confirmed by section 11002C, which states that the purpose of this title is to grant the Public Utility Commission the authority to make and enforce rules necessary to protect customers of telecommunications and electric services consistent with the public interest. So we have PURA that deals with electric and telecom utilities. We're over here in the Water Code, Chapter 13. It has its own judicial review provision, 13.381. It does not have an analogous stay provision. And we think that's significant. Where the legislature grants that authority, within the confines of an act, but doesn't do so in another context. We think that's significant. So that provision that they rely on for this court's authority to grant the extraordinary relief that they're asking for here simply is not applicable to the specific appeal of the orders that issue here under the Texas Water Code. And so, perhaps there's some authority in the court's equity jurisdiction to issue a TRO, but even still, plaintiff hasn't met their burden of showing that they meet all of the required elements of a TRO. First, there's no imminent or irreparable harm here. The harm claimed by plaintiff here is that they will incur expenses on an independent appraiser to in carrying out this compensation phase. Mr. Miller mentioned the two-part compensation phase. But that's the statutory process that was laid out by the legislature. If we look at the statute, the streamlined expedited release statute, it says that the Utility Commission may require an award of compensation, as it has done here in its order. And if it does so, then the statute itself lays out the compensation process that the commission has to follow. It lays out the deadlines. The first deadline, which is significant here, is that within 10 days of issuance of or approval of the petition or issuance of the order, the petitioner and the utility must negotiate and try to agree on an independent appraiser. If they do that, then the petitioner landowner bears all of the expenses of the appraiser. So the plaintiffs here had an opportunity within the statute created by the legislature to avoid the very expenses that are now creating this emergency that they're requiring, that they're saying they need a temporary restraining order for. If they don't agree on an independent appraiser within 10 calendar days of the approval of the petition, then the statute sets out this process that within 70 calendar days, they each will engage their own independent appraiser to be paid for at their own expense. So this is baked into the statutory process. The legislature made this process and anticipated that these parties would be paying their own expenses for their appraiser if they don't avail themselves of the opportunity to avoid that cost by agreeing on an independent appraiser with the landowner. So essentially, they are asking this court to step in and halt this statutory process. The PUC is simply following the statute here. Their choices within this process, they've had 60 days already to try and engage to either try and work out an independent appraiser that they wouldn't have to pay for or engage their own appraiser. Their choices within the statutory scheme do not create an emergency for this court that would end. And they've also failed to show exactly what this harm looks like. They've made bare bones conclusory allegations that they will incur quote, significant public fund, they will have to expend significant public funds to pay for their own appraiser plus half the cost of the commission appointed appraiser as required by the legislature in the statute. But that's it. Other than Mr. Miller's quote today that it may be tens of thousands of dollars, they've not shown any concrete facts about what kind of expenses they're looking at beyond bare bones and conclusory allegations that it will be significant. And lastly, I'd like to point out to the court that under the commission's rules in the compensation phase, one of the factors that the commission can consider in assessing the valuation of the property is necessary and reasonable legal expenses and professional fees. Whether or not that includes any portion of their or the entirety of their independent appraiser fees, it is clear that they can recover at least some of their legal fees incurred in this process. And so they're not without legal remedy. On the harm that they've alleged regarding the service that will be provided by the city should the compensation phase be completed or be allowed to be completed. They've not shown that they are receiving compensation for any services, any water services provided to the tract right now, or that they have in the past received compensation for water provided to the tract. So they're not missing out on known service to that tract. Could they in the future perhaps provide service? Yes, but assessing the costs of that and showing irreparable harm from losing those revenues that they're not currently even providing to that tract to another service provider is just not the type of irreparable harm that would warrant this court stepping in and stopping a state agency from carrying out its statutory duty to complete this compensation phase. Excuse me. And should the court consider the likelihood of success on the merits, we'd like to remind the court that this is a suit for judicial review of an agency order. That's the sole cause of action that they've alleged here. So the merits at final hearing on the merits will be under the substantial evidence rule as provided by 13-381. Under the substantial evidence rule, the agency's orders and findings are presumed to be valid and supported by substantial evidence. The burden is, of course, on the plaintiff to prove otherwise. And so they will have the task of showing that the agency's order is not supported by even a mere scintilla of evidence, given the reliable and probative record as a whole. So we would just ask that the court consider that should you reach the merits, although we don't think that's necessary here, or reach the likelihood of success on the merits. And then lastly, we would also like to remind the court that this is a suit for judicial review of the agency's order under the APA. And the default under the APA is that when a suit for judicial review is filed, that doesn't affect the effectiveness of the agency's order. So the default is that there's no stay of an agency order on judicial review. And we don't think that plaintiffs have provided any statutory or other legal authority beyond general equity jurisdiction for this court to exercise the extraordinary remedy of halting an agency's compliance with the statutory process and consider in continuing an ongoing agency process. So for those reasons, we would ask that the court deny the TRO.
Okay. Thanks, Ms. Snowdy. Mr. Tuckfield.
Yes, thank you, Your Honor. I'll be quick. I think it's critical and important what Ms. Snowdy said about this court's jurisdiction and ability. The Texas Supreme Court expressly held that Texas Government Code 2001-174, which is cited by the plaintiffs in their original petition, quote, allows state courts to reverse or remand existing agency orders, but does not allow state courts to enjoin future ones. And 2001.174 is what governs here. The utilities code provision cited by Mr. Miller doesn't apply, as Ms. Snowdy pointed out. So this court doesn't even have the ability to issue a TRO in this case. Now, it's interesting that Mr. Miller pointed out that if you don't stop this compensation proceeding, another utility might be able to provide service in the future. So he's trying to use this compensation proceeding to hobble the landowner and keep the landowner from doing anything. He's trying to use this temporary restraining order to avoid the effect of the order that the first step, right? Because the first step has already happened. It's been decertified, but now the landowner has to wait to get through the second step before they can do anything. So he's not just trying to stop this second step. He's causing that first step to be set aside. So he's getting a substantive, if you grant the TRO, he will get a substantive ruling on the original step one and just stop everything. So that's critical here too. As far as the alleged injury, the injury and the emergency is a phantom issue. The order was issued August 15th, 2024, 62 days ago. There's 8 days left. If it was such an emergency, this should have been brought 61 days ago. 62 days has elapsed. It's disingenuous to say that they haven't already spent the money on their appraisal. I doubt that they've just been sitting doing nothing. I'm sure they've already spent all this money, whatever the appraisal is, to get this done to be able to file next week. 87% of that time has already elapsed. And yet we're here at the very end finish line with them alleging, oh, with 8 days left, all of a sudden this is a big emergency. Obviously it's not, because if it was an emergency, they should have done that a long time ago. And as Ms. Snooty pointed out, this compensation phase actually provides money to them, and it includes necessary and reasonable legal expenses and professional fees. I think Mr. Miller also said that they'd have to share in the cost of the third party appraisal. The statute, I believe, says that the petitioner pays the full cost of that third party appraisal. So the harm is just minimal. The harm is to the landowner. The landowner now has been decertified, has gotten their land out of the CCN of Rose Hill. They have to go through this second phase that doesn't last that long in order to be able to do anything else. But they want to stop that second phase so that the landowner now is stuck in this purgatory and hobble the landowner from doing anything until the appellate process runs its course over how many years it might be. So they're using this TRO is just kind of a phantom process to actually get a ruling on it. So importantly, this court doesn't have jurisdiction. The emergency isn't really an emergency. The purpose is to preserve a TRO is to preserve the status quo. Well, this would not preserve the status quo, as Mr. Miller pointed out. The status quo right now is that once we pay the compensation, we can go get service from someone else. He wants to stop that process. He wants to stop that in the future. So that does not preserve the status quo. And then just, I don't want to spend much time on the substance. Mr. Miller reads crystal clear very broadly, but he omits very important provisions and crystal clear statements and crystal clear such as a tract of land is not necessarily receiving water service simply because there are facilities or water lines near or even on that tract. If, for example, such facilities are used to provide water only to other tracts, that 8-inch line is providing water to other tracts. There's never been a contract between the landowners and Rose Hill. There's never been payment for water. These landowners have never received water service from Rose Hill, ever. And so the likelihood of success on the merits are minimal as well. But most importantly, there's no emergency here. And this court doesn't have the jurisdiction to actually issue that TRO pursuant to the Patel case in the Supreme Court, and that's 2015. Thank you, Your Honor.
All right, thank you. Before I let Mr. Miller have maybe a very short rebuttal, let me ask Ms. Snowdy, because I don't think I heard it, and I am curious if there is a reason I'm going to hear about as far as why did the commissioners do the opposite of what their staff and what the ALJ recommended?
Yes, Your Honor. I think there's a disagreement about what, and this is, as Mr. Tuckfield and Mr. Miller both hinted at, what it means to be receiving water service within, the meaning of the crystal clear case and within the meaning of the statute. And so where the ALJs found that, given certain facilities or commitments of facilities to the tracts, the ALJ found that under its interpretation to be receiving water service for purposes of the statute, whereas the commission found that based on the record and the facts presented that there were not sufficient facilities to show that the tracts were receiving water service. So it's a disagreement between the interpretation of what it means based on the evidence in the record for that tract to be receiving water service. And so that's going to be the heart of, the suit for judicial review. That's going to be the key issue is there evidence in the record to support whether this tract is receiving water service? Did the commission, is there enough evidence to support the commission's decision there? But that reversal from the ALJ's recommendation is based on a difference of looking at the evidence and determining under the legal standard what receiving water service means for these tracts.
So the people that work at the PUC, the staff and the ALJ have a different meaning for receiving water staff service than the actual commissioners. That's the explanation for
that. I mean, the explanation of change is that they looked at the evidence, and I see Mr. Tuckfield wants to weigh in here. He was involved at the agency itself, but is that yes, they look. The commission is the ultimate decider of the weight of the evidence here. And so the commission looked at the specific facts and the evidence in the record and determined that under the legal standard that it did not meet the standard for receiving water service. So they have the same, everyone understands the crystal clear governs, what receiving water service is and what the standard is under the statute. The commission looked at the record and the evidence and the facts and reached a different conclusion than the ALJ. And it's within their purview as the commission, as the ultimate decider of and trier of fact to make that change. Mr. Tuckfield, I believe, wanted to weigh in.
Okay. Quickly, if you don't mind, I've got to get to other TROs that are flowing in.
Sure. I just want to point out that we do have this memorandum from the commissioners that explained why they changed it, and Mr. Miller alluded to that memorandum. But there is
from the chair,
from the chair to the other commissioners, and the bottom line is that the commissioners said, "Look, if you're not actually receiving water, you're not receiving water," and that was it. But there is a basis in the record for this.
Okay, well, that's what I was curious about. All right, thank you, sir. And Mr. Miller, briefly, I really do.
Yeah, got it. I mean, there's so much I'd like to respond to, but just to focus on probably the most important point, Your Honor, we think that the 15.004 of the Utilities Code applies, but really, if it doesn't apply, that's just beside the point, because all that section really does is say that the court shall exercise its equity jurisdiction according to its normal standards. And that's what I went through. I went through you have that jurisdiction, that equity jurisdiction to issue TIs and TROs. And we went through the requirements that are found in the common law regarding your equity jurisdiction. And I believe I showed that all those requirements were met. In talking about that issue, about your general equity jurisdiction, I believe Mr. Tuckfield cited a case that talked about 2001 of the government code and about enjoining future orders of an agency. We're not trying to enjoin a future order. We're looking at the order that was issued, the orders that were issued on August 15th. Ordering provision says, the proceeding to determine the amount of compensation to be awarded to the CCN holder, if any, commences on the date of this order in accordance with the schedule adopted in order number 5. Any decision on compensation will be made by separate order. So it's the same proceeding, but it's a separate final order. We're looking to enjoin that ordering paragraph in the August 15th order. It's not about a future, we're not looking towards a future order. I think that's probably all I need to cover. I will just, I guess the only thing I'll point out is if you look at the rule that talks about the factors that evaluation report must cover, and that's on page 8 and 9 of tab D, you'll see, I mean, I think it's pretty plain that it's an involved report. And yes, we've engaged a an expert appraiser. He's done some work, but he certainly hasn't by any means finished that work. And we are seeking to relieve Rose Hill of the burden to finish that work, to spend more money on it, money that's and put itself in a position where the city of Terrell would be able to legally provide water to this tract, which would constitute irreparable harm. These are areas that Rose Hill has the exclusive right to provide water service to, not another entity.
All right, counsel, I appreciate your time. Let me ask a question of you. Today we took these two cases up together. I'll just ask you this. Do you think the cases should be consolidated for other purposes? Is that something y'all discussed, or you want them to work their way up separately?
Your Honor, I would say that they need to be they need to be put before the same judge. I don't know, assigned to the same judge. I don't know if a consolidation is necessary.
Yeah,
But
the only way they would probably be heard by the same judge is if they were consolidated. That's not the way 10.2 cases get assigned.
There's no-
Sorry, from the commission's perspective, we would oppose consolidation of these because the administrative record on them will be different. The administrative and record as far as the factual determinations that the commission made, they are very similar, but they do involve two separate administrative records and separate factual findings that will be reviewed. That being said, we can put in the 10.2 assignment letter that they're related and should be assigned to the same judge, whether that's possible or not.
Yeah. I don't know.
We can at least note that in the 10.2 letter.
in fact, we
Sure.
filed a 10.2 letter because we were required to in order to seek TRO. And we mentioned that in the.
Okay, well, that's a Judge Meacham question, so I'll let her do what she does with those. But I just was curious, so I will, I'm gonna think about this a little bit more. I'll get you an answer probably by 5 or maybe 6 today. And appreciate your time in the virtual courtroom, and take care. You're excused.
Thank you, Your Honor.
Your Honor.